folks, and welcome back to Contract Law. This is video 2 in the video series on remedies, and in the first video we did a bit of an overview and we started our excursion into the wonderful world of damages. We had a look at some of the nuts and bolts and the issues of causation, remoteness and mitigation. And in this video we're going to have a look at the rather interesting question of calculation of damages. We'll look at a couple of heads of damage and also the issue of liquidated damages. So, looking first at calculation of damages, the big ticket item to take away from this discussion is the principle in Robinson and Harmon, which is an 1848 case, the foundational case in this area of law, that damages in contract are intended to put the plaintiff into the position as if the contract had been performed. That is, as if everything had gone off successfully. So what the plaintiff is essentially getting is their lost expectation, their expected profits out of the deal. That is the beauty of damages in contract. Generally speaking, the way that they're calculated will be the difference between the contract price and the value of the property, usually calculated at the date of the breach. These kinds of damages are called general or unliquidated damages. Now, why do I say that they're a beautiful thing? Contrast damages in tort. These are sometimes called out-of-pocket damages. So you'll only get monies expended in reliance on the naughty conduct, in reliance on the tort. For example, monies that you paid out for the contract price, money spent in performing whatever part of the contract has been performed. So these are sometimes also called reliance damages. The idea behind tortious damages is that you're getting the plaintiff back into the position that they would have been in had that wrong never been committed, had the tort never happened, okay? You're getting the plaintiff back to this, what we call the status quo ante, another awful Latin phrase, how they were at the beginning before the tort happened. Very, very important to keep these two types of calculation distinct in your mind. Tort gets the plaintiff back to the beginning, how they were at the beginning. Contract gets them how they would have been, to where they would have been at the end of the contract if everything went well. Damages in contract only cover your net loss that you can prove. If you can't prove any loss at all, the court's just going to give you nominal damages, and by nominal damages I mean really nominal. Normally the court will just give $1. Now if that is the case and you also fail to get costs in the action, then you're going to be out of pocket an awful lot of money. Yes, you might have actually proved your cause of action, but if you can't get any damages out of it, it's going to be a very expensive exercise. If you can't precisely prove your damages, your loss, that's not going to be any difficulty really. In this area of the law, calculation of damages is often said to be more of an art than a science. The court will just do its best to work with whatever evidence it has to try and calculate your loss. How and TIFI is the authority there. As I said before in the last video, there's no exemplary or disgorgement damages. The court doesn't award extra sums to wave their waggly finger at a naughty defendant. They'll just give the plaintiff the money that it will take to compensate for their loss. So, looking at the nature of expectation damages, unliquidated expectation damages, how does that all work? As I say in the slide there, this is where contract damages are most at home. The measure will generally be the difference between the contract price and the difference between market value as at the date of breach. So A sells to B 10 tonnes of apples at $1,200 a tonne. A fails to deliver, B has to buy the apples on the open market, but on the open market they're $1,500 a tonne. So B's loss is $300 a tonne. That is the amount that they would claim in damages in contract. Yes? One of the heads of loss that you might claim in damages is wasted expenditure. This is also a natural part of getting the plaintiff into the position that they would have been if everything had gone well. That is, if you spend money in forming a contract where that money was going to be recouped by the plaintiff at the end of the day, then you can certainly claim that as wasted expenditure. So the example here, A contracts to build a house for B for $200,000. A, the builder has to spend $150,000 in actually building the house, so the anticipated profit will be $50,000. If partway into the contract, A has spent $50,000 on materials and then B repudiates and says, sorry, I don't want this house anymore, and the contract is terminated, A, the builder, will get their $50,000 wasted expenditure that they've already paid out in materials for the house, and they will also get their $50,000 expected profit on the contract. The net result of all of that is that they'll be $50,000 better off, won't they? They'll get their $50,000 back that they've already paid out, and they'll get the extra $50,000 profit that they wanted to get when they were making the deal. Commonwealth and AMAN Aviation is the case to look at here. And in this case, AMAN had bought some planes for aerial surveillance. The Commonwealth was had put out some tenders for quite a lucrative aerial surveillance role up in the top end of Australia. And AMAN was so keen to get this contract that it proposed a loss leader arrangement with the Commonwealth. That is, it would buy the planes that were necessary for the surveillance at a cost of around $5 million. And they knew that they wouldn't actually recover all of that $5 million on the first period of the contract. What AMAN was really pinning their hopes on was that they would spend out all this money, make a loss, but then when the contract was up for renewal, they'd already have the planes, and pretty much whatever money they made there would be more of money for jam, if you know what I mean, just more profits rather than a lot of expenditure. The plane's resale value was less than $1 million. Unfortunately for AMAN, the Commonwealth reported to terminate wrongfully, as we've already discussed in previous video series, and so AMAN accepted the repudiation and claimed damages from the Commonwealth. AMAN obviously wanted to get some wasted expenditure here because of the huge cost of the planes that it had bought in anticipation of the contract. The problem was that you can't get wasted expenditure or money that you've spent in reliance on the contract if that money wouldn't have been recouped at the end of the contract. Remember, the ideal or the aim is to get the plaintiff into the position as if the contract has been performed. If you weren't going to make your money back, well, you're not going to get that as wasted expenditure. Accordingly, the trial judge only awarded $410,000, which was the profit that they would have actually made on that first go of the contract term. They fought it all the way up to the High Court, and eventually it was held that AMAN could actually claim damages for wasted expenditure. Why is that? Because, and this is where I say calculation of damages can smell a bit more like an art than a science. There was at least a possibility of AMAN getting that contract renewed when it came up for renewal. And there was a presumption that the party, most sensible parties, including AMAN, won't enter a contract if they wouldn't recover costs, at least ultimately, in their anticipated events. So here the court said the Commonwealth would likely have renewed the contract, or as I said, at least it was a possibility, even though they couldn't work out what the exact possibility was. So a man would have at least recouped their expenditure. That meant that they could be compensated for the expenditure, and they were awarded around $6.6 million. That included wasted expenditure not only on the planes themselves, but for all sorts of other associated costs that they had laid out in anticipation of the contract, including staff that they had to hire and then fire, so termination payments as well. So that is the value in wasted expenditure claims. And then we need to look at the issue of mental distress. Generally speaking, courts tend to shy away from damages for mental distress or things like injured feelings, disappointment, and all of that kind of thing. They're far more comfortable with hard, quantifiable monetary loss. Why is that? Well, because there are usually claims in tort that can be made, but also because pretty much every breach of contract is going to involve some level of distress, stress, disappointment, and so on. If you let all of these kinds of claims in without reservation, then unfortunately you might find that the floodgates were opened, and the issue of awarding plaintiffs' damages kind of really got out of control. However, there are always, as we are finding out with contract law, there are exceptions. The first is where the plaintiff suffers some kind of actual physical discomfort or inconvenience, and the mental suffering or stress is directly related to that inconvenience. So in the Hobbs and London and South Western Railway case, 19th century cases, you can probably imagine, Mr. and Mrs. Hobbs buy train tickets to get to their destination. However, the train was stopped before the destination for repairs, so they decided to travel on foot to their destination. The problem was that it rained heavily, and they got caught by cough and cold. Mr. Hobbs sued for the physical risk and illness. Score, yes, he was able to actually get damages here for his physical discomfort. £8 damages in those days, a fair amount of money, for the physical risk and inconvenience, which flowed as a direct loss from the breach of contract, but not for the illness, which was said to be an indirect loss and not compensable, not directly linked to the breach. The next exception is contracts for enjoyment and relaxation, and where that is the whole point of your contract, and the breach means that you get something far worse, and as a result you have some mental distress, then you might find that your claim in damages is successful. And here we have Baltic Shipping and Dillon, and in this case, dear old Mrs. Dillon had suffered the loss of her husband some months previously. She wasn't even in such a good shape, and her family encouraged her to buy a ticket for a pleasure cruise. She was set to sail on the Mikhail Lermontov from New Zealand to Australia. It was to be a 14-day cruise, but unfortunately the ship sank on the 9th day. Dear old Mrs. Dillon survived. What a winner. Not only did she survive, but she certainly became determined to enforce her rights against the company. She sued in restitution for recovery of her fare, and we'll talk about that in another video in this video series. But she also sued for damages and mental distress. She was successful there because the object of the contract was, what they said, freedom from molestation, essentially enjoyment, relaxation, pleasure. And the ship sinking clearly was ran directly counter to the object of the contract. So her distress flowed directly from the breach, the sinking of the ship, and therefore she was able to successfully claim in damages here on Mrs. Dillon. All right, so the last thing we need to look at here is lost reputation. Generally speaking, much like damages for mental distress, damages for lost reputation or impugned reputation are not compensable. Why is that? Because usually you can sue in defamation, which is a tortious action. However, there are a couple of circumstances where you might be able to claim damages for diminished reputation. Firstly, where there has been damage to business reputation, and secondly, for authors and actors where they've lost an opportunity to enhance their reputation. Go and have a look at the Wilson and United case and the Flamingo Park and Dolly Dolly case there. So that is damages for mental distress, and now we need to look at, very briefly, at the issue of liquidated damages. And what are liquidated damages? They are simply a clause within the contract that is an attempt to put a price on a breach by one of the parties. And why would you do that? Because you'll recall earlier in the other video, earlier in this series, we said that you have to, usually when you're claiming unliquidated or general damages, you need to prove your loss in order to get the damages. If you are suing on a liquidated damages term in a contract, you are actually filing a claim or an action in debt to recover debt, rather than a claim for damages per se. So you don't have to go and prove whatever loss it is that you've suffered. You're just saying to the court here, the contract says that I am due to be paid X dollars. These kinds of clauses are fine enough for the parties if they are a genuine pre-estimate of the loss that might flow from that kind of breach. The problem is that usually these kinds of clauses are inserted to enforce the other party to comply with the contract in terrorem, that is, in terror that any breach by them might incur the wrath of the liquidated damages clause and an inflated sum that they have to pay. So the court developed this doctrine of penalties, and if the liquidated damages clause goes far further than is necessary to really compensate the innocent party for their loss, if they are not a genuine pre-estimate of loss, then they will be struck down as an offensive penalty. That is, they may well be void. Nevertheless, if the liquidated damages clause is void, you can still certainly fall back on your option to claim for unliquidated damages. And the case that kicked off the doctrine of penalties was the 1915 Dunlop pneumatic tyres case, which you might remember from an earlier video in this unit. Dunlop had supplied tyres to New Garage. New Garage had agreed not to do a number of different things, including selling less than a certain list price. New Garage had agreed £5 liquidated damages for each tyre that they sold in breach of those terms. You guessed it, New Garage sold at less than the list price, so Dunlop sued. And it was held that Dunlop could recover its liquidated damages and that they were not a penalty on the facts of that case. Rather surprising, given that nowadays that would be about $500 per tyre penalty. Note also that the outcome would probably be different nowadays because of the anti-competitive nature of that agreement. But Lord Dunedin, as I said, set down some principles. Just calling the term liquidated damages isn't going to win favour with the court. They'll have a good hard look at the substance of the agreement and whether or not the clause was a genuine pre-estimate of loss. The factors that Lord Dunedin set out, the overriding factor really is that it will be a penalty if it's extravagant and unconscionable compared to the greatest loss that could flow from the breach. There has been some recent movement in case law around this area, but this is the main factor that's really stood the test of time. Other factors to consider, it might be a penalty if it's imposed for a failure to pay money and the liquidated damages are a higher amount than the actual sum due. It might also be presumed to be a penalty, although that's now contentious, if there's a single lump sum imposed as damages, but the breach by the other party may either cause very serious loss or very trifling loss. Also, and this harks back to something I said earlier, just because pre-estimate of damage is difficult won't necessarily make it a penalty. If the parties on examination of all the facts in the context of the case, seem like they've tried to pre-estimate their losses just because they might have gone a bit over and above. It doesn't necessarily mean that it's going to be struck down as a penalty. Andrews and ANZ is the recent, relatively recent High Court case that has had some influence here. And it seems as though courts are more amenable to liquidated damages clauses than they used to be. These clauses used to be routinely struck down. Now, after Andrews, it seems that if compensation can be given to the innocent party for any prejudice, then the court may well enforce the liquidated damages clause to the extent that compensation can be provided. Another more recent case, the Picotio case, that involved late fees on credit cards. As you can imagine, people were getting a bit annoyed at the high fees that were being imposed by the ANZ there. However, the court said they were not disproportionate and they were enforceable by the ANZ. More's the pity, I guess. So they are the main factors that flow from Dunlop. As you can imagine, there are a number of different ways of getting around the rule. In Andrews, they said if you can link your liquidated damages payment to some kind of additional service or accommodation that you've made for the other party, that might be okay. In the waterside workers case, they said if the damage to the other party's interests is insusceptible of assessment in money terms, if it's really super hard to work out what the actual damages will be, then it's potentially less likely to be struck down. Another mechanism was set out in Stroden Parker, and that is where the parties agree on a very high sum to be paid from one party to the other, and that sum is then reduced if the other party performs as they are supposed to under the contract. So there, what you're not doing is waiting for a breach to trigger the liquidated damages clause. You are simply agreeing on a very high price to be paid or a large sum to be paid, and that sum is reduced if proper performance is delivered. Kind of a sneaky mechanism, but you've got to respect that. That's the one in Stroden Parker. Deposits are another interesting subset of issues in the penalties discussion. And I'll leave you to look at chapter 16.640 and 650 in law for that discussion there. So that is the issue of damages. And it's about time to end off this video here. So I will go across to video 3. And until then, bye for now, guys.